Good afternoon, guys. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to provide you some updates regarding a new USCIS policy that will affect mostly applicants for employment authorizations, those who are filing for adjustment of status, and those who received deferred action. Primarily, these are people who are under orders of supervision with final orders of removal. So let's talk about that. On January 14th, 2021, USCIS issued a new policy alert called Applications for Discretionary Employment Authorizations involving certain adjustment applications or deferred action. And it's a 17-page document. It goes into describing various ways a person can work in the United States legally. For example, there are situations when the person does not need an employment authorization, but rather has it automatically because of the status. If a person is a green card holder, if a person, of course, is a citizen, if a person is asylee or refugee, and some other situations. Then it goes for explaining that in certain situations, a person can apply for an employment authorization and it's automatic. For example, a fiance of a US citizen will automatically receive an employment authorization. But then it says that in certain situations, USCIS can exercise discretion, whether or not, even if the law says that you are eligible to file for an employment authorization, to give you that employment authorization. And the policy focuses mainly on two major instances of when, from now on, USCIS is going to exercise that discretion. And the policy, according to this document, is effective immediately. And those two main situations are when a person is an applicant for adjustment of status and when a person is subject to deferred action. And I'm going to tell you that those are very large two groups of situations, so-called, because there are many people who are waiting for adjustment of status, let's say based on marriage. And this policy, of course, is very important for them because unlike previously or currently or 2 days ago, when the person would be filing for adjustment of status, he or she almost automatically would receive an employment authorization. This new policy says that it's not going to happen like that anymore. It's not longer going to be automatic. Now, I have to tell you, I do not know how long this policy is actually going to stay in place, taking into consideration that we have a new administration coming in, but it's something worth discussing and know about, especially because whatever change is going to happen cannot happen overnight. All right. So first, we're going to talk about discretionary factors that USCIS is going to take into consideration when a person is subject to deferred action. All right. So USCIS on page in the end of the policy, basically section C says that in deciding whether an alien granted deferred action should be granted an employment authorization, USCIS makes a case-by-case determination, considering all relevant information. Now think about this. Currently, or before this policy got into effect, a person who has deferred action only had to demonstrate that he or she complied with order of supervision requirements and had economic necessity. And it would be just a simple explanation why you need an employment authorization to work legally in the United States. Well, now it changes. So here is a list of discretionary factors, and they can be positive and negative. And according to this new policy, a USCIS officer will have to weigh on these factors to make a decision whether or not you deserve employment authorization. So, the favorable factors, as they call them, are the alien has demonstrated economic necessity. to work in the United States. The alien is a primary source of financial support for their U.S. citizen or lawful permanent resident spouse, parent, or child. So you will have to have those qualifying family ties, right? Uncle or grandma is not sufficient. The alien or the immediate relative has medical condition that would cause significant financial hardship should the alien not be granted an employment authorization. So you need to work basically to pay the medical bills. The alien has an absence of any significant criminal history. The alien has demonstrated need to stay in the United States for a prolonged period of time to assist law enforcement, investigation, or prosecution. And if the alien is a spouse, parent, or child of a U.S. citizen, or the alien is a member of the U.S. Armed Forces or in the selected reserve of the Ready Reserve, and is currently servicing on active duty, or if discharged, served honorably. So these are the favorable factors. It seems that if you are an immediate relative of a U.S. citizen, this is a favorable factor. If you have somebody who needs medical attention and you're paying their bills, including yourself, this is a favorable factor. And if you are a primarily source of income for the family, this is a favorable factor. But here is a list of unfavorable factors. Well, understandably, there will be criminal convictions like aggravated felony, DUI, domestic violence, sexual assault, or child abuse. But then we have something more than that. Then unfavorable factors include the length of time the alien was or has been in the United States without lawful presence. The alien has committed fraud in order to obtain an immigration benefit. I wonder if they take into consideration the possibility of a waiver or not. The alien has knowingly aided or abetted any person in violating U.S. immigration law. And it seems here that you do not need to have a conviction, but just some information for you to be subject to this negative factor. The alien has lied or made a material misrepresentation to any immigration or consular officer or employee while such officer or employee is performing his or her official duties under law. Well, consider this situation. You enter the United States on a visa saying that you were married when you were not. Whatever happened later, and now you're subject to deferred action. Guess what? That information on that visa application may prevent you from receiving an employment authorization under this policy. And of course, the alien is a national security or public safety risk as evidenced by arrests and criminal convictions. I'm going to tell you that usually if you are subject to national security risk, you wouldn't be enjoying a deferred action. But according to this factor, they judge it based on arrests and criminal convictions. So the officer may herself or himself determine that you are subject to national security risk just reviewing your criminal record. And according to this policy, all these factors, including the length of stay in unlawful status in the United States, are going to be a way to determine if you deserve an employment authorization. So this is a huge shift in policy. And I'm not sure if it's such a fair one. I would say that it's not, of course, because many of these factors are kind of don't have specific guidelines, right? They don't have whenever we have a room for interpretation, there is a risk of interpretation being unfair, depending on who is interpreting. And of course, it says that if your employment authorization is denied because of these factors, there is no appeal, but you can file a motion to reopen or motion to reconsider. And another part of that policy goes into explaining how an applicant for adjustment of status cannot enjoy an automatic employment authorization either. The policy itself, interestingly, does not contain specific factors that, unlike with deferred action group, that will be taken into consideration when a USCIS officer decides whether or not to give you an employment authorization while you're waiting for your green card. But rather it references another chapter of the USCIS policies manual, and I reviewed that chapter, and I'm going to tell you what those factors are, the factors that will be taken into consideration when USCIS decides whether or not to give you employment authorization. Consider a situation: you married a US citizen. You entered the country legally, of course. You have a legal admission for adjustment of status. You spent here 10 years. Now you met a US citizen. You guys are married. You are very happy. You are submitting your documents for adjustment of status and for an employment authorization, as we did for many years together. But now that employment authorization is not going to be automatic. And in addition to the regular application, you actually have to submit other evidence showing that you are entitled to that employment authorization, that favorable discretion should be exercised. So which factors are going to be taken into consideration? The first one is eligibility for the benefits sought. This is very interesting because eligibility usually or sometimes can be a question of law, but apparently an officer will be deciding whether or not you're eligible for the benefit you're ultimately filing for on the stage of deciding whether or not to give you that interim employment authorization that you can use while waiting for your green card. Then there is a factor, ties, family ties in the United States. I guess if you're filing for adjustment of status based on marriage, you should be able to demonstrate that, right? Value and service to the community. Hardships you may have if the employment authorization is not granted. History of employment in the United States, as well as if you have property in the United States, business ties, if you're operating a business, if you've been paying taxes, and if you owe any taxes. If you were overall a law-abiding citizen, your criminal history, of course, your immigration history, including any fraud, misrepresentations that you committed. This is another interesting factor because, as I stated, and you may be aware, there are waivers that many people are eligible for, waivers of fraud and misrepresentation that often will be filed together with the application for adjustment of status. So this is the new policy. I would say that I disagree with that just because the factors that they propose to use are very subject to a lot of interpretation, and I would be surprised that someone may make such a conclusion of law if somebody is eligible or not eligible for benefits sought at the early stage of filing. Because as I said, there are certain circumstances where the issue is not that clear. Besides, as you may be aware, sometimes when the issue is not clear, USCIS is going to issue a request for more evidence so that you can clarify your eligibility. Of course, it's always on you to prove that you're eligible or not for benefits sought according to the United States immigration law. But basically, in my view, it would be unfair to make a determination of eligibility for the entire application in connection with just an employment authorization. But we're going to see, as I said, how this policy is going to be implemented, if it's actually going to be, even though it says that it's effective immediately, how long it's going to stay in, or maybe it will be revoked very soon. So thank you very much for watching. I hope you enjoyed this video. So please like, share, and subscribe to my channel, and I hope to see you soon.